Good morning. My name's Harley Schachter. I am legal counsel for Whitesand and Red Rock First Nation. Red Rock and Whitesand First Nation 25 years ago brought this case that is 175 years in the making. It was a long time coming. Today, the Supreme Court of Canada has agreed that there's been an unjust and unfair process by Canada and Ontario. They have not honored the treaty obligation. Indeed, 25 years ago when Whitesand and Red Rock took on this case, the government said there was no obligations. There was no treaty right to an increased annuity. There was no right to share the wealth of the treaty territory that was part of the traditional territory of the First Nations. Today, that is over. Today, the Supreme Court of Canada has ruled that there is a treaty obligation to share in the wealth of the treaty territory by way of increased annuities from time to time. Today, the Supreme Court of Canada has answered that treaty rights are constitutional rights. Today, the Supreme Court of Canada has made sure and expressly stated that the governments are not above the law. They do not have unfettered discretion to decide if there should be an annuity increase, when it should be. That matter ultimately is for the courts to decide if the governments do not act honorably in accordance with principles of respect, responsibility, reciprocity, and renewal, all Anishinaabe principles of law that govern the treaty relationship and will in the future continue to govern the treaty relationship. The government, the Crown, says the Supreme Court of Canada today, has 6 months from the release of this decision today, 6 months, to sit down with us to negotiate an honorable resolution of the past grievances about what the past, the compensation for the past. If they do not, then they must pay what they believe is owed, and the matter would go to court. And Justice Hennessy would be called upon at that point to provide guidance on what an appropriate remedy would be. But the clock is ticking, and we are looking forward to negotiations with the Crown, and we are hopeful for a positive resolution. I can say that today's decision is a victory for democracy as well as for our clients. It's a victory for our clients because for 175 years, the governments, like a fox in charge of a chicken coop, claimed that they alone had unfettered discretion to decide on whether there was any wealth to be shared. Meanwhile, when the First Nations asked the court for help, the governments argued that the courts have no role to play. The fox, if you will, insisted that they alone were in charge. Well, today that fairy tale ends. Today, the Supreme Court of Canada made clear that the fox is not in charge of the chicken coop, and the treaty annuity promise must be fulfilled in accordance with the honor of the Crown. If I can put it another way, and perhaps mixing metaphors, after 175 years of abject and dishonorable neglect on the part of the Crown and refusing to honor their treaty obligations, the government's chickens have now come home to roost. Now, if Ontario and Canada do not come to the table, the Supreme Court of Canada has given us a remedy and a path forward, and we're very, very grateful to the Supreme Court of Canada and look forward to prosperity for my clients and an opportunity for them to share in the economic benefits of our great country. Thank you.
Can I just ask a quick fact question?
Yes.
In terms of beneficiaries, the judgment talked about 2017, roughly 13,500 individual beneficiaries as part of the Superior Anishinaabe group. Red Rock and Whitesand are two First Nations that are on the judgment, but I'm assuming there's more First Nations communities.
It is all the Robinson Superior treaty beneficiaries that benefit, and the court was clear in saying that it's a collective entitlement for the First Nations benefit.
Do you know roughly the number of communities that are party to this?
There could be as much as 12 First Nations that are involved with a population of approximately 15,000.
How much money will you be seeking for this? And I mean compensation, obviously, passed.
The amount of compensation, we've actually had a phase 3 discussion about that, and it ranges from anywhere from a couple billion says Canada to as much as 126 billion, but the range for the plaintiffs is a reasonable range between those amounts, and it would be preferable, says the court, for the parties to decide what that amount is, whether it's 10 billion, 20 billion, 80 billion. It would be it would be preferable, says the Supreme Court of Canada, for the parties to reach that rather than the courts. But if there cannot be an agreement among the parties, the court ultimately retains the power and authority to remedy that by awarding an amount, or the court could say, we're going to ask you to reconsider it. We don't think that that number is correct. Ontario, Canada, go back to the table.
But you're unsettled for $10 billion. Do your clients believe they are owed more than that?
My clients believe that my clients are owed more than $10 billion, and maybe the Hurons are owed more than $10 billion as well. I would not want to exclude that as well.
What's your message to the governments of Canada and Ontario going into these negotiations, given that you now have the court to fall back on if you don't reach an agreement?
Well, my message to Canada and Ontario is come to the table with an open heart and in the spirit of reciprocity, reconciliation, should lead the way and lead a path to an honorable resolution of somewhere between the amounts that I've mentioned, which is consistent with the evidence in stage 3. We had a lot of economic experts telling us what wealth there was to share.
The only thing I'll add to that is the court today found that the Crown has severely undermined the spirit and substance of the treaty, and so going into these negotiations are an opportunity for the Crown to remedy that, to work towards enhancing and reconciliation in the honor of the Crown, but also the spirit and the substance of the treaty.
Oh, I'm sorry.
Yeah, sorry.
Hello. My name's Spencer Bass. I'm counsel for Biigtigong Nishnaabeg First Nation. Firstly, I want to say that aujourd'hui, ce jugement-là est une victoire historique pour les personnes Anishinaabe de la nord d'Ontario et pour tous les Canadiens et Canadiennes. Today, the highest court in this country has recognized what our clients have been saying for decades. The $4 per person that the government has been paying under the Robinson Superior Treaty is shocking, and it makes a mockery of the treaty promise. Those are not my words. Those are the words of a unanimous Supreme Court of Canada. The court was also unanimous in declaring that the Crown has breached the treaty. They wholeheartedly rejected Ontario's attempts to throw out this case on technical arguments around the statute of limitations, and compensation must now be paid. The court has given the Crown a roadmap to change their conduct, to pay our clients what they are owed. And if they do not, if they continue and they persist in their dishonorable conduct that has lasted for more than 150 years, then we will do what the court said we can do, and we will return to the court and force them to act honorably. I would now turn it over to members of Whitesand and Red Rock who wanted to say something.
Bonjour. Go discuss among them up downs in Calabunjian. I'm really happy about the decision that came today. Our legal team mentioned 25 years This started all from 50 years ago when our former chief at Whitesand started this process. Chief Doug Sinaway and I used to talk about the treaty money that we used to get, which is $4. And he figured at that time, wasn't worded. And I'm glad that today came where I can tell Chief Doug Sinaway that we have a decision, but we still have work to do. Because
What a great day. I'll just say thank you to Harley and Caleb for all their tireless hours working for us. I'm newly elected. I'm like 3 months in, but I was at the meeting when they first gave the go-ahead to fight this course along with Whitesands. And I'm standing here proud to finally see something going our way. Thank you.
Do you think we could get you to tell us your name? Sorry.
Oh, sorry.
Just
Yeah.
in front of
Yeah, Chief Allan Odawa Jr. Yeah, sorry. From Red Rock Indian Band.
What's the name again?
Chief Allan Odawa Jr.
Okay. And the other gentleman?
sorry, I started off in the Ojibwe language saying that my name is Owl's Foot from the Lone Clan from Whitesand. I'm the chief of Whitesand currently. First Nation, my given name is Lawrence Wanakamik, chief of Whitesand. Miigwech.
Are there more questions?
Are there any more questions?
I have to tell us, can you speak to the precedent that this sets for other First Nations in Canada who are, in dispute with the federal government, with the Crown, over treaties?
Well, the first thing is that the decision is long and complicated, and it'll take a little bit more time to digest. But some general thoughts are reconciliation among First Nations is a key component of the future relationship between the government and First Nations. Sharing, respect, responsibility, renewal, reciprocity, these are Anishinaabe principles that animate that relationship. And it's a sacred relationship about sharing among nations. And as we move forward as a country, this is a signal to us as Canadians, really, to work together for the betterment of all Canadians. What is good for Anishinaabe people is good for Canada. So it's a victory for everybody.
Some really strong language in this ruling, including that Canada or the Crown made a mockery of treaty rights. Was any of that surprising to you?
No. In a word, no. It wasn't surprising that there was harsh words and condemnation. It has been 175 years of abject neglect and complete refusal to abide by a promise which was effectively to share the wealth of the treaty territory in that simple terms. And in that simple terms, the court does say that this is a treaty about sharing and sharing of the wealth to the betterment of both.
Can you
Yes.
just weigh in a bit on what the ruling says about the fiduciary duty and the honor aspect and the differences there?
All right. On the issue of fiduciary duty, the court did say that the fiduciary duty, the relationship exists, but that the honor of the Crown fills the role, this is my interpretation, that the honor of the Crown fills the role that fiduciary duty used to take. They, in black letter law terms, they said the fiduciary duty does not apply in this case because there isn't what's called a cognizable Aboriginal interest. It's kind of legal technicalities, but it doesn't apply. But from our perspective, it doesn't need to apply if the honor of the Crown is as robust as the Supreme Court of Canada has ruled it to be.
Does that represent a shift by the Supreme Court in terms of its interpretation of the honor of the Crown?
I don't believe it's a shift. I believe it's a along the continuum of where the law on the honor of the Crown is developing. It is developing with an eye on reconciliation as opposed to the law of fiduciaries. So the role for the honor of the Crown is expanding, I will say that. And it's interesting, perhaps a historical factoid, that the principle of the honor of the Crown was first coined or first discussed not in Mikisew Cree in 2004 or 2005, excuse me, but in the Supreme Court of Canada in 1875 in this very dispute in the annuities case. That's where the Supreme Court of Canada in Mikisew picked up the idea that the honor of the Crown has a role to play in Aboriginal and treaty rights litigation. So it's kind of full circle, and we're moving forward, I hope, to a better Canada for sure.
Thank you so much.
Yes. More questions? No? That's it? Thank you.
Just what will this settlement mean for your community? How will this change the lives of people in your community?
It'll change a lot of lives. For the biggest thing is they'll be able to be healthier. That's the biggest thing, is health for my First Nation.
And for you, we heard you say you were just elected, but what does this mean for you as chief of this community?
Well, it's how can I put this? The past chiefs and council did all the work. I just come in at the end to sign papers. So I'm thankful that the past chiefs kept it going. I know some rocky roads, but yeah. So it's, and plus the community gave the okay, because it's the community that puts us in here, and it's the community that can take us out.
How much has this issue been kind of a sore spot in terms of reconciliation in First Nation?
Yeah, it's been a sore spot. Yeah, for many years, for many of our people. I wish this was done like right away back in '96 or '99 or whatever year it started. I wish it didn't take this long, like 25 years. It should have happened like right away. That way, the people that pass can enjoy it too. But now that they're gone, at least their families can enjoy it. So, yeah, very happy day today.
How will you celebrate?
Go to my camp, relax. Yeah. Thank you.
So the question was, what does this court case and this court victory mean to Whitesand First Nation?
Bonjour, miigwech. I know I have a kind of a voice that you can't really hear, but I'm happy that today came after 175 years, and it's a long time coming. We have suffered all those years, no economic benefits to our community, and it's been hard over the years trying to make a whole community for Whitesand. Again, I forgot to mention who I am, Chief Lawrence Wanakamik, and over those years we struggled, to get to this point. Like I'd mentioned, the late Chief Doug Sinaway started this off over 50 years ago when we first started the Whitesand First Nation. And that's when we contacted Harley and Neil Duboff and Caitlin Lewis here to work on our case. And to get to this point today is, it's really, actually I get really emotional when the announcement came, when they came down. And really happy that today is finally here. We can start and make our community, our whole community, a healthy community, and to build our community into a real community, for people to start having benefits that the whole mainstream society has been getting over these years, and we're happy that this is going to be a start point, another starting point for Whitesand First Nation getting into economic. I guess to realize that we can do what we can do with economy in our area and in our First Nation. We do have other struggles to contend with, but with this with this settlement, it'll make things. We'll have a better community from this point on.
I heard you say that you've been working on this for 25 years. So what does this feel like today?
Well, like I said, today it feels like I said, I'm very emotional about hearing the news that came down when our legal team came down and informed us that we had won. You guys got to my heart that it's finally here. It's really good to hear that, and I always think about our late chief Taksinaway, and like I said, he had. We talked about that over 50 years ago. To start something like this, and also to build our First Nation into a community. And like I had mentioned, we have struggled, and we're still struggling today, and trying to make a real community, a healthy community.
Thank you.
I can just spell his name if anybody's curious about that. Yeah, okay, excellent. It's Wanakamik, Lawrence Wanakamik, Whitesand First Nation. Okay, thank you.